Hello, thank you for joining me today. My name is Michael Cardamone, and I work in our Bluebell, Pennsylvania office. We only represent injured workers in Pennsylvania. We never represent the employers or insurance companies. I graduated from Boston College in 1996 with a degree in philosophy and the Villanova University School of Law in 1999. I passed the bar exam in Pennsylvania in 1999, and I'm licensed to practice law in Pennsylvania. Today, I will be discussing the Pennsylvania workers' compensation settlement process from the perspective of a claimant's, that is, an injured worker's attorney. Some of the topics which we will address today are timing, valuation, the effects on employment and other benefits, the compromise and release agreement itself, and the in-court settlement procedures. When is a good time to settle a Pennsylvania workers' compensation matter? The simple answer to that is when the claimant and the employer or its insurance carrier or third-party administrator are ready, willing, and able. Sometimes this is 2 months after an injury, and sometimes this is 2 years after a work injury. Remember, it takes two to tango. Many injured workers believe that they can force a settlement. This is not true. The insurance company and the employer have to be willing to settle a workers' compensation case. It's a voluntary decision on their part. If an injured worker is receiving workers' compensation checks, the injured worker cannot force a lump sum settlement. The employer and the insurance company has to be willing to negotiate. For a claimant, it is generally a good idea to wait until the medical treatment has become a management situation rather than active treatment involving injections, physical therapy, or surgery. If the treatment is active, it makes sense to try to bargain for a period of open medical benefits so that the injured worker can receive the treatment that he or she needs before they settle out the medical component. If the insurance company is pushing for a close of the medical benefits, you need to be careful to make sure that the injured worker has an alternative means of insurance, such as medical insurance through a spouse or Medicare. The insurance companies aren't always willing to entertain a period of open medical benefits. They place a lot of value in having the claim closed in terms of the indemnity or the cash part of the case, in addition to the medical benefits. The emotional burden of the entire process of a workers' compensation case can overwhelm an injured worker, and this can often make the settlement an attractive option for the claimant. They get spied on at times by surveillance companies that the insurance carriers hire. Sometimes the injured worker's checks are late. They have to go to independent medical doctors, sometimes every 6 months. And it can be demoralizing for an injured worker. And sometimes this is an incentive for them to settle the case. Another thing to be careful about is to maximize the impact of other available benefits outside of Pennsylvania workers' compensation. For example, is the injured worker receiving Social Security disability benefits in addition to the workers' compensation checks? If so, there are cases where the Social Security disability check will actually increase after a Pennsylvania workers' comp settlement occurs. And so this can be another incentive for an injured worker to settle his or her case. The next topic I want to discuss in this presentation is what benefits can be settled. A Pennsylvania workers' compensation settlement will address essentially three types of benefits: wage loss benefits, medical benefits, and specific loss benefits. Wage loss benefits are based on the injured worker's loss of earning power, and this is calculated using an average weekly wage and a compensation rate, which is 2/3 of the average weekly wage. Each year has a maximum rate. For 2012, the max rate is $888 per week. In the same regard, if the average weekly wage is low for an injured worker, the comp rate can be as much as 90% of that amount. Medical benefits are based on the accepted diagnoses in a controlling document, which is often the Notice of Compensation Payable, which we attorneys in Pennsylvania abbreviate as an NCP. The employer or its insurance carrier or third-party administrator must pay for treatment that is reasonable, necessary, and related. Specific loss benefits are benefits that involve a set amount of weeks for either amputation or the permanent loss of use of a member of the body, binaural hearing impairment of greater than 10%, loss of vision in one or both eyes, and also disfigurement. In a global settlement, that is when all benefits are resolved, all of these benefits must be addressed in the agreement, which is called a compromise and release agreement. We practitioners in Pennsylvania workers' compensation call the agreement a CNR for short. And that is pursuant to Section 449 of the Pennsylvania Workers' Compensation Act. The majority of compromise and release agreements in Pennsylvania will provide a lump sum to the injured worker, and that is something that the injured worker's attorney and the attorney for the insurance company negotiate. In addition to the lump sum amount, the parties will discuss what happens to the medical benefits. So you will normally see language in the agreement regarding the payment of reasonable, necessary, and related medical expenses. In most cases, the medical benefits will be paid for treatment up until the settlement hearing itself. And then from that point forward, the injured worker, in most cases, not all of them, but in most cases, will release the employer and its insurance carrier from any further liability. In some cases, as we discussed earlier, the medical benefits are left open. And the period of time that they are left open for is, again, something that is bargained for. You could agree to 6 months of medical benefits after the settlement hearing. You could agree to 2 years. As long as the parties agree, there are no limits on that. Sometimes the insurance company will try to specify which specific treatment will be covered and which won't. For example, in some settlements that I've had, the insurance company has been willing to pay for medical benefits for a defined period of time, but they want to limit exactly what type of benefits they're going to be paying for. For example, they might agree to 6 months of open medical, but not agree to pay for any surgical procedures. So they may agree to pay for physical therapy, office visits, and prescription medicine, but not for injections, for example, into the back or a back surgery. The next issue I want to discuss today is how much is a Pennsylvania workers' compensation case worth? And this is one of the first questions that we claimants attorneys often hear when we're contacted by an injured worker. A Pennsylvania workers' compensation case is worth whatever an employer and the injured worker are willing to accept. That's the short way of putting it. There are many factors in play here in terms of evaluating and analyzing the value of a particular case and its settlement value. The average weekly wage of the injured worker is important. That is, how much money did they gross in an average week before the date of injury, and that determines the compensation rate. What their job duties are, the restrictions that their treating physician has placed upon them, whether the employer alleges that they have work available within the injured worker's restrictions, and whether a bona fide job offer has been made, whether maximum medical improvement has been reached, and simply stated, that concept means whether the injured worker has plateaued. And if they have, they're often deemed to have reached maximum medical improvement. And basically that means that the physician does not expect them to get better, nor does the physician expect them to get worse. Another issue is whether an impairment rating evaluation has been completed. Once an injured worker has received temporary total disability benefits, that is, they've been out of work and receiving a full workers' comp check for 2 years, the insurance carrier, that is, can request an impairment rating evaluation to be performed. And if that evaluation results in an impairment of 50% or greater, then the injured worker's benefits will continue indefinitely for temporary total disability. That is, they're not converted to a partial status. If that examination results in an impairment rating under 50%, and in the vast majority of cases it does, the injured worker's status converts from temporary total disability to partial disability, and that doesn't necessarily reduce the amount of the injured worker's checks. In fact, it doesn't do that, but it converts them to a partial status. And what that means is the insurance carrier has a cap or a ceiling on the amount of checks that they have to continue to pay. And that cap in Pennsylvania is 500 weeks. So if there's an impairment rating that has been performed, and if that rating has come up with a percentage of impairment at less than 50%, the injured worker will have a cap of 500 additional weeks for their checks. Another issue is whether there's been a labor market survey. And that occurs essentially when the pre-injury employer has confirmed that there is no work available within the injured worker's restrictions. Then they hire a vocational expert to do a labor market survey. That is an analysis of the local economy where the injured worker resides, and they account for the injured worker's medical restrictions, their vocational abilities, their age, and factors like that, and they look for open and available employment that allegedly fits the injured worker's physical and vocational abilities. The vocational expert issues a report and essentially opines whether the injured worker has an earning power. And in most cases, they do find some kind of earning power. And if successful, when they petition the workers' comp judge, that can lower the amount of checks that an injured worker receives. And therefore, that can reduce the value of the settlement. Another factor, of course, to consider is which judge is presiding. Although all the judges are fair and come at the cases with an objective perspective, naturally they all have their own backgrounds and histories and experiences. And so you find that some judges are a little bit more liberal and some are a little bit more conservative. And that can play a little bit of a role in terms of the value of a settlement, because if there's a petition pending and it's before a given judge, that may tell you whether your odds are higher or lower in terms of a successful outcome. Always keep in mind that the 500-week max, if partial disability applies, that's an important issue. And you also have to keep in mind the time value of money. a dollar today is worth more than a dollar tomorrow. And so the injured worker, if they receive a lump sum, they can do a lot more with that money than trying to simply live on the weekly or biweekly checks. They can invest it, earn some interest on it. They can use the money to further their education, and so on. Mediations with the workers' compensation judges in Pennsylvania can help bridge the gap in negotiations. The mediations can be mandatory or voluntary. And essentially, a mediation is a meeting, and it's less formal than a hearing. There's no court reporter. But it's a meeting with the judge, the injured worker, the injured worker's attorney, and the insurance company attorney, and usually the claims rep is available by phone, if not in person. And it's a meeting where the mediating judge attempts to settle the case. And usually they're very successful in doing that.
Please take a moment to write down Lawline.com's first verification code. Lawline.com's first verification code is the word BEYOND, all in lowercase, BEYOND, BEYOND. Please take a moment to write down Lawline.com's first verification code. Lawline.com's first verification code is the word BEYOND, all in lowercase, BEYOND, BEYOND.
Not required to settle his or her case. Even if the mediating judge recommends a settlement at a certain figure, the injured worker is not required to settle. The mediation is simply an attempt to resolve a case. Although in reality, when a workers' compensation judge recommends a certain figure, in most cases we see the case is resolving. The workers' compensation judge is not concerned with the amount of the settlement at the settlement hearing. The mediating judge might be, but not the judge who's presiding over the settlement petition itself. The workers' compensation judge who is presiding over the petition to settle the case, his or her sole focus is whether the injured worker understands the full legal significance of what they're doing. That is, the judge has to find that the injured worker understands the benefits at issue and what benefits are available and which ones they are giving up. The next topic that I want to discuss today is what factors increase the value of a Pennsylvania workers' compensation settlement. The failure to reach MMI, maximum medical improvement, and we discussed that a little bit earlier, that is a component which increases the value of a settlement in terms of the injured worker. If they have not reached MMI, that means the injured worker is looking at additional treatment, which could involve surgery. And that can raise the stakes in terms of the settlement value because the insurance company doesn't know how much the procedures are going to cost, how many will be done, and so on. A high average weekly wage is a factor that increases the value of a settlement for the injured worker. If they made $1,000 a week before the work injury and their workers' compensation check is $666 a week versus somebody who made perhaps $350 a week who's getting a workers' comp check of closer to $300 a week, well, that makes a big difference in the numbers. When you're calculating the value of a case and looking at a figure in terms of how much is 1 year of workers' comp wage loss benefits, you use the compensation rate, and a higher rate will obviously lead to a higher figure. And again, for 2012, the max rate is $888 a week. And that's true even if an injured worker made $1 million in a week. They're capped at $888 a week. Restrictions from the treating physician. This is an important component for evaluating the value of a settlement. If the treating physician opines that the injured worker can't work at all, or that they have many restrictions, that will, of course, increase the loss of earning power. And the loss of earning power is a critical component in terms of evaluating a workers' comp settlement in Pennsylvania. Another issue that's extremely important is whether the independent medical examiner, that is the insurance company's doctor, has issued an opinion that the injured worker is fully recovered or that they need ongoing restrictions. The independent medical exams are with doctors who are handpicked by the insurance company. And the insurance company is entitled to do this every 6 months or up to 2 times a year. The independent medical doctor, or the IME doctor, is not a treating physician. They examine the injured worker, they review medical records, they take a history, and they render an opinion as to the diagnoses, whether those diagnoses are work-related, and what restrictions, if any, they believe are reasonable. It goes without saying, if the independent doctor claims that the injured worker is recovered, then that can affect the value of the case because they're going to file a petition to terminate benefits, and that gives them a shot at having the case closed down pursuant to a judge's order. And that has to be factored into the equation. In terms of that issue, the injured worker's attorney will analyze who the doctor is and also who the judge is and whether they've had cases involving similar fact patterns and what the outcomes were. A young age will have an impact. An injured worker who has a herniated disc at the age of 35 may have a more substantial loss of earning power than somebody who might be 65 and may be on the verge of retirement and out of the workforce. The education level of an injured worker is also a critical component. When you're trying to determine the loss of earning power, it's critical to look at the education level of the injured worker. If they have a low education level, that tends to increase the value of the case because it'll be more difficult for the vocational expert or the insurance company to find work available within the injured worker's restrictions. And conversely, if the injured worker has a college degree or a master's, etc., that will make it easier for the employer to establish an earning power. It'll be easier for them to find sedentary work, which is work at a desk or sitting down, than it will be for a laborer whose skill set involves heavy lifting and a lot of physical exertion. Let's now discuss which factors decrease the value of a Pennsylvania workers' comp settlement. Again, if the independent medical doctor claims there's a full recovery, the injured worker must be on high alert, essentially, that their benefits could come to a halt. If a petition is filed alleging a recovery and the IME doctor is found to be credible by the judge, then the benefits will be shut down. A low average weekly wage, and we discussed this earlier, will lower the value of a case. If you're looking at the numbers involved and the numbers are low, then the settlement figures tend to be lower. Again, maximum medical improvement. If that has been reached, that can lower the value of a case, or it may not. It just depends. In many situations, it lowers the value of a case, as it generally signifies the treatment will calm down or the injured worker is leveled off. But there are cases where an injured worker has reached MMI, but they have significant disability. And so if they've plateaued with significant disability, then that can lead to many years of disability and a loss of earning power. Another issue is whether there is an alleged job offer from the pre-injury employer asserting that they have work available within the injured worker's restrictions. If that's the case, then the workers' comp judge will have to determine whether the injured worker is capable of performing that work and whether the work is actually available. And on that issue, a lot of times there's a medical disagreement as well that has to be analyzed. The insurance company's doctor may assert that the injured worker's restrictions involve simply no lifting over 50 pounds. And for example, the treating physician might say the injured worker's restrictions are no lifting over 10 or 15 pounds. And so there'll be a lot of issues in that litigation. Is the job actually available? Is the job within the injured worker's restrictions? Which restrictions are more appropriate? And so on. And as we discussed earlier, is there a labor market survey that has been completed? If it has been completed, and if the vocational expert alleges that there's an earning power, that can impact the value of the case and lower it, because if they are successful in establishing an earning power, then that will lower the value of the case accordingly. The next issue I want to discuss is, how do I approach the insurance company about settlement? Essentially, the injured worker's attorney will initiate the process with a demand, and that is a letter or a phone call or an email outlining what the injured worker wants and dealing with the wage loss, the medical benefits, and any specific loss that may apply. Generally, I think it's a good idea to put this in writing so that there's a paper trail, and I think a letter tends to be a better idea than simply an email. The demand is oftentimes seen as unreasonable by the insurance company, and I caution against getting into a war in terms of characterizing the offer or the demands as reasonable or unreasonable. I find that to be counterproductive, and that leads to tension rather than progress, in my opinion. When you send a demand letter, some attorneys will explain their reasoning for the figures, and other times the demand will simply state what the figure is and what the terms are, and won't really get into an analysis about how those figures were arrived at. It's important to it's important to not use a bottom line approach. And what I mean by that is, it may be tempting at times to simply start negotiations for an injured worker by stating what the bottom line is in order to streamline the process and to make it go faster. But when I've done that in the past with good intentions, a lot of times what happened is the insurance company, claims rep, or their attorney will then use that as the starting point and offer something lower than that. So it can be painstaking at times, but I think the better approach is to start at a figure, wait for the insurance company to make an offer, and then counter it. The majority of demands will be structured like this. The claimant will settle her workers' compensation case for a lump sum of X amount of dollars, medical benefits for treatment up until the compromise and release hearing, and my firm's litigation cost. Some adjusters will respond to this demand quickly, And other times it can take weeks or months to get a response. Sometimes the adjusters have to get the demands and the offer to the demand analyzed by someone a little bit higher than them in the pecking order. And that process can take time naturally. Remember again, the insurance company is not required to settle. If an injured worker is receiving workers' compensation checks, they are not required to offer a lump sum amount. It's a voluntary decision on their part. However, in most cases, the insurance companies place a lot of value in that finality. And so you find out that in the vast majority of situations, they are quite interested in trying to negotiate a lump sum to end the case. The next thing I want to discuss today is what effect will settlement have on a claimant's employment. Many of the employers will require a resignation as part of the workers' comp settlement. That resignation is not an issue for the workers' comp judge to consider, but as part of the contract, if you will, or the agreement between the injured worker and the employer in terms of the settlement of the work comp benefits, the employer often wants to part ways, and they usually come to the settlement hearings with a document essentially stating that the injured worker agrees to resign and not seek re-employment. Here you want to be careful with language about a voluntary quit. If the language states that the injured worker is voluntarily quitting, that can disqualify him or her from unemployment compensation benefits. A lot of the injured workers will apply for unemployment compensation after the workers' comp settlement, and if they had signed an agreement at the workers' comp settlement hearing agreeing that they voluntarily resign, that language can be held against them and disqualify them in the unemployment compensation setting. Because to get unemployment compensation, you need to be able and available to work and not working because of a necessitous and compelling reason. But you can be disqualified if you have voluntarily separated yourself from employment, or if there was a termination for willful misconduct. Claimants are often cynical about the prospects of future employment opportunities. However, my experience is that most injured workers, after they settle their case, will in fact find employment. It takes time, of course, for some of them to do so, but my experience is that most of them will find employment within about a year or so or less. Many injured workers feel an enormous weight off their shoulders after the settlement. It allows them to focus on their future and what they can contribute to the workforce based on their residual physical limitations. Another issue to think about is what prospective employers may find out about the workers' comp settlement. And essentially, on a job application, the employers can ask whether there's anything that would prevent the injured worker from performing the material aspects of a job. They can't necessarily get into a discussion about did you have a work-related injury and so forth. Let's now discuss how a Pennsylvania workers' compensation settlement will affect other kinds of benefits. Again, be careful with any language in a resignation from employment, as again, that language can come back to disqualify an injured worker from unemployment compensation. If the injured worker is receiving Social Security disability benefits, those benefits will likely be adjusted by Social Security. If an injured worker is getting workers' compensation wage loss benefits and Social Security disability benefits, the workers' comp is not reduced by the Social Security disability benefits, but the Social Security disability benefits may be reduced by the workers' comp. However, after a lump sum settlement, the Social Security disability amount oftentimes goes up. And in the compromise and release agreements, that is the workers' comp settlement agreement in Pennsylvania, we cite a case called Sciarrata versus Bowen. And in my PowerPoint presentation, I state the citation, which is 837 F 2nd 135. And that was a Third Circuit opinion from 1989. And essentially, it allows the injured worker to spread out their portion of the workers' comp settlement over their expected life using these tables so that they can keep the workers' comp settlement and also get a Social Security check on a monthly basis, but it'll just be reduced by a certain amount using a formula. Also, be mindful of short and long-term disability benefits before you settle a case for your client. Read the plan to determine the eligibility beyond a separation from employment, as a lot of those plans will have language that states upon the end of employment that the benefits will end. Let's now talk about how the settlement process works in workers' compensation court. If you have a petition pending before a workers' comp judge, such as a claim petition, or if there's a petition to modify, suspend, or terminate that is pending, you want to amend one of those petitions to a petition seeking approval of a compromise and release. If there's no petition pending, you can file a petition seeking approval of a compromise and release agreement. It'll get assigned to a workers' comp judge, and then there will be a hearing where the injured worker testifies about the terms of the agreement. And the judge has to determine whether the injured worker understands the full legal significance of the agreement. The agreement must be explicit with regard to payment, if any, of the reasonable, necessary, and related medical expenses. Of course, the lump sum amount, if there is one, that must be stated clearly. The vocational evaluation, there's a statement about that on the form, and in the vast majority of cases, the injured worker will waive their right to a vocational evaluation. The idea being that they know what kind of work they can do. Most of them have worked their entire lives, and that's just sort of a formality that is waived by the parties. There's also a verification of child support that must be submitted to the workers' compensation judge. And of course, if somebody has child support payments and if they're in arrears, then that has to be worked out with domestic relations of the given county before the injured worker can receive any of their settlement funds. The fee agreement of the between the claimant, that is the injured worker, and his or her attorney must be attached to the workers' compensation settlement agreement. That fee is normally 20% unless it's otherwise modified. And the compromise and release agreement must leave out language regarding other issues outside of the wage loss, specific loss, and medical benefits. Again, as we talked about earlier, the employer may want a resignation. They may want a general release where the injured worker agrees that as part of the settlement, they're not going to sue the employer for any other types of violations of law outside of workers' comp. And the injured workers, it's okay for them to agree to those things, but the workers' comp judge will not be interested in those issues. So in the compromise and release agreement itself, that is the agreement presented to the judge, the only things that should be discussed are the effects of the medical benefits, the wage loss benefits, and the specific loss benefits. And any other agreements are between the injured worker and the employer, which do not have to be approved by the judge. There's a 20-day right to appeal. That is, the injured worker Once they have the hearing regarding the workers' comp settlement, they're entitled to appeal that decision within 20 days. And most of the injured workers waive that right to appeal so that they can receive the settlement proceeds quicker. And so basically, when the judge approves the agreement, they will issue an order approving the settlement. And from that date, the injured worker will receive his or her benefits, the lump sum amount that is within a 30-day period, if they waived that 20-day appeal period. If they didn't waive that appeal period, the settlement proceeds will take a little bit longer in most cases. If the injured worker does not receive the workers' comp lump sum amount that they were promised in the agreement within that 30-day period, again, assuming that they waived the 20-day appeal right, then the injured worker's attorney can file what's called a penalty petition. And that's basically where you ask the workers' comp judge to penalize the insurance company or employer for their failure to pay within the allotted time. And the workers' comp judge can award up to a maximum of 50% of the amount at issue as a penalty. Another issue I want to discuss today is, can the workers' comp settlement be undone? In other words, can a claimant back out of the agreement once it's approved at a hearing before the workers' comp judge? Again, once the compromise and release is approved, the injured worker is entitled to appeal within a 20-day period. However, the appeal cannot be based on the worker simply changing his or her mind. If they settle their case for $50,000 and they testify that they understood what rights they're giving up, that they were doing it voluntarily, that they hadn't consumed any drugs or alcohol that morning, that they weren't promised anything outside of the agreement, that it was their signature on the paper, etc. And if the judge approved that agreement and the next day or the next week or the next month, the injured worker thought to himself or herself, well, that wasn't enough money, their odds of getting that settlement set aside or overturned are extremely slim.
Please take a moment to write down lawline.com's second verification code. Lawline.com's second verification code is the word continent, all in lowercase, CONTINENT, continent. Please take a moment to write down lawline.com's second verification code. Lawline.com's second verification code is the word continent, all in lowercase, CONTINENT, continent.
The appeal instead must be based on the idea that the worker didn't fully understand the legal significance of the agreement. They would file a petition to set aside the compromise and release, and it will not be set aside unless they can show that there was either misrepresentation, concealment, a mutual mistake of fact, or fraud. And in this regard, note that at the settlement hearings, there's a court reporter, and that reporter takes down the injured worker's testimony when they're being questioned about the terms of the agreement, whether they understand it, whether they did it voluntarily. And the parties can request a copy of that transcript, and they can look back to that transcript to determine whether all of the issues were discussed and whether it appears that the injured worker did understand what was happening. In my experience, it is pretty rare that an injured worker wants to undo a settlement, and it's even more infrequent that they have any success doing so. So it goes without saying, it's very important for the injured worker's attorney to carefully go over the terms of the settlement, with his or her client before that settlement hearing, and to go over the questions that they'll be asked at that hearing so that they have a heads up about what issues will be addressed to prevent any misunderstandings. It's very important to have a plan in place. A lot of injured workers will want to settle their case, but it's really important that they do so having a plan for their future in mind. And some of the issues here are whether they're going to have an income stream coming in after the settlement hearing. If they have a lump sum check that they're receiving as part of the settlement, a lot of that may go to bills or an investment. And if they have no other income in the family, they need to figure out, of course, how to survive financially. If they can't work, if they're totally disabled, have they talked to a Social Security disability attorney? And if so, what are the odds that they'll be successful in getting a Social Security disability check? If the injured worker can work, then they obviously want to think about posting their resume, completing the resume, updating it. They may want to speak to a vocational counselor, make sure they're on LinkedIn, and take advantage of social media and those types of things. If the lump sum is significant, I often advise my clients to talk to a financial advisor. As an attorney, of course, you cannot dispense financial advice, but I think it's okay to connect them up with a financial advisor so that they can put the money to good use. Another issue is whether the injured worker has health insurance. Again, as part of the settlements, most of the insurance companies really push for a complete termination of all benefits. And if the injured worker has no way to pay for the workers' comp treatment, then they need to figure out who will pay for it. If they have a spouse, maybe they have insurance that they can become part of, or perhaps they have Medicare. But in any event, it's very important to consider what type of insurance they will have. The next thing I want to discuss today is the compromise and release agreement form itself. That is the agreement that is presented to the workers' compensation judge for approval at the workers' compensation settlement hearing. It's called a compromise and release agreement pursuant to Section 449 of the Pennsylvania Workers' Compensation Act. And if you look in the materials, you'll see a copy of that form. The first page, it will have the employee's name and address, the employer's information, and the insurance company information as well. And then there'll be paragraphs 1 through 4 on the first page, and that information is essentially background information, such as the date of the injury, the average weekly wage of the injured worker, the workers' compensation rate, which again is generally 2/3 of that amount, and the precise nature of the injury at issue. On the second page of that agreement, starting at paragraph 5, the insurance carrier and the claimant will agree to some more facts in terms of what benefits have already been paid or that are due and unpaid. And then paragraphs 6 through 10 are really critical components. They state the basic agreement between the parties. It'll say, is this compromise and release agreement a resolution of wage loss benefits? Is it a resolution of medical benefits? Is it a resolution of specific loss benefits? And again, as we discussed earlier, they're the three main types of benefits that are at issue with the Pennsylvania Workers' Compensation Settlement. There's another paragraph about whether the claim involves the death of an injured worker. Of course, in the vast majority of cases, it does not. The paragraph 10 is really the most important paragraph because it summarizes the deal. It'll state essentially the amount of the lump sum award, if there is one, and the terms of the medical benefits and specific loss in a paragraph form versus just checking off boxes as you do for 6 through 9 on that form. Number 11 on the compromise and release form, or I should say paragraph 11, talks about whether there's a lien for subrogation. And what subrogation means is the right to reimbursement. If an injured worker has a third-party case as part of the workers' comp injury, that is, if they had sued someone other than the employer for personal injury, for example, if the injured worker was driving for work and they were involved in a car accident, they could have the workers' compensation settlement or case, but also a third-party case against the driver of the person, the car that hit them. And if they recover money in that third-party case, then workers' compensation, the insurance carrier, has the right to subrogation or to get reimbursed for some of the proceeds from that third-party settlement. And so that issue has to be addressed in terms of what reimbursement they're going to receive from any third-party case. Number 12, paragraph 12 of the compromise and release form deals with child support or spousal support orders. And again, there's an affidavit that goes along with the settlement. And we also do a lien search for child support to make sure that if there are arrears, that is handled ahead of time so that the injured worker is not receiving a lump sum amount while violating a child or spousal support order. The next paragraph is 13, and it tells you to list any benefits that are received by or available to the claimant, such as Social Security, disability, private health insurance, etc. And it's important to make sure that if an injured worker is receiving Social Security benefits, that you list what kind. For example, is it retirement or disability? Paragraph 14 discusses Medicare, and in all the workers' comp settlements in Pennsylvania, the parties have to account for Medicare's interest. Medicare does not want to pay for future work-related treatment, and the parties have to put language in the agreement to protect themselves and to show Medicare that the parties are not shifting the burden of future medical treatment unfairly to Medicare. In fact, in a lot of cases, there's a Medicare set-aside that is done whereby there's a set amount of money that the injured worker receives for future medical treatment that they account for and report to Medicare. And then once that money is exhausted, then Medicare will pick up whatever they cover. Number 15 is the vocational evaluation topic. And again, most injured workers will waive by mutual agreement, actually, with the insurance company, the right to a vocational evaluation, or in some cases it's already done. Paragraph 16 talks about the issues involved in the claim and the reasons why the parties are settling the case. In this paragraph, there's usually language, the settlement is in the best interest of the parties, and sometimes some other more boilerplate language that the parties are doing this voluntarily and it's going to resolve all of the pending litigation. The fee agreement, as we discussed earlier, between the injured worker and his or her attorney must be attached. That's an important component of the settlement papers. Paragraph 18 discusses the litigation cost, and the insurance companies are usually paying the litigation costs over and above the lump sum amount. Number 19 is a paragraph, sort of a catch-all provision, to state any additional terms and provisions of the agreement. The next page is the employee certification page, and that's where the injured worker will initial at the top part of that document if they had an attorney of their own choosing or if they did not have an attorney. If they did have an attorney, then they're verifying that the attorney has explained the content of the settlement and its effects upon the injured worker's rights. And then at the bottom, the injured worker must sign where it says employee signature. The employee's counsel, if there is one, must also sign, and then somebody for the employer or insurance company. The parties must have either two witnesses to the injured worker's signature on the document, or alternatively, the injured worker can have his or her signature notarized. So they have a choice in terms of how they proceed with that. In most cases, I find that we're using the witness boxes instead of the notary. A lot of times we actually receive good copies of the settlement agreement at the hearing itself, and in terms of the originals, and it's just easier to get some witnesses at the hearing than have it notarized. And that's essentially the compromise and release agreement form. It's a standard form, must be filled out correctly. It must be explicit and clear in terms of all of the terms of the agreement. It must be signed and either witnessed or notarized. It must have the child support documentation attached, and it also must have the fee agreement attached. There'll be brief testimony at the hearing, and the vast majority of cases, the workers' comp judge will approve the settlement as long as the injured worker understands what the deal is and what rights they're giving up. I want to circle back for a minute before I conclude to paragraph 4 of the compromise and release agreement. That paragraph, again, states that the parties are to list the specific nature of the injury and whether the disability is total or partial. This paragraph is very important. And what I mean by that is you have to be very careful to put down the specific diagnoses that are being recognized. And I say this because I've had cases where the injured worker has unpaid medical bills, and in order to analyze whether those bills are the insurance company's responsibility, the first thing you do is you pick up the compromise and release agreement and you look at the language in that agreement in terms of what injury the insurance company was taking responsibility for. And so in paragraph 4, the attorney should be very careful to make sure the diagnoses are those that have already been accepted, either in a notice of compensation payable, a supplemental agreement, a prior stipulation, or a prior decision from a workers' comp judge. So whatever one of those documents governs and is the controlling document, you want to take that language in terms of the diagnoses and insert it word for word into paragraph 4 of the compromise and release agreement. And that way, if there is an unpaid bill that falls between the cracks, the claimant or his or her counsel can figure out whether that bill should be paid for by the employer or the insurance carrier. And so that language must be carefully construed as part of the workers' comp settlement. Well, that ends my discussion today of the Pennsylvania workers' compensation settlement process. I want to thank you for joining me. And if you have any questions, you can reach me directly at 215-206-9068.